Welcome to the latest Evershed Sutherland Legal Insights podcast.
Hello and welcome to the first episode in this Legal Insights podcast series. In this series, we'll explore some of the legal risks that can arise from operational disruptions in financial services, and we share practical tips to help you build resilience and recover from these disruptions in this evolving technology-driven global enterprise landscape. In this particular episode, we'll be discussing these operational risk issues specifically in the context of the senior managers and certification regime. So to introduce myself, my name is Kieran Walker. I'm a consultant in our Financial Services Regulation and Governance Group, and I'm delighted to be joined by my colleagues, Simon Collins, Managing Director of the Financial Services Regulatory Advisory Practice in Connexo, Claire Carroll, who is a partner in our Financial Services Disputes and Investigations team, and Sophie White, partner in our Employment, Labour and Pensions team. So Simon, if I can turn to you first and
Sure.
Maybe start by asking you if you could perhaps give us a brief overview of those aspects of the SMCR that you think are relevant for these operational resilience issues.
Sure. And thanks for that, Kieran. I think firstly, SMCR is very much the hub for a significant number of different regulatory initiatives. If we think about, for instance, consumer duty, and also obviously operational resilience, then the SMCR is very much at the forefront of FCA's thinking, particularly around governance and the performance of senior management. So if you think about what firms have got to look forward to, by 31st of March, they need to be ready to meet the new operational resilience requirements that the FCA and PRA have set out for all of the sort of larger financial services firms. And if we think about what actually these firms have had to do to get in place, the identification of important business services, the setting of impact tolerances, the mapping, for instance, of processes, technology and third parties who are instrumental in maintaining operational resilience, the undertaking of scenario testing, making sure that they've identified any remediation aspects or vulnerabilities that they have within their organization and what recovery plans they've had to put in place. All of that falls squarely on the shoulders of the senior management team. And they will have had to have undertaken a self-assessment that demonstrates what role the board and certain senior managers have played to date and will be playing moving forward into the embedding of their approach to operational resilience into their day-to-day way of working and also their overall culture. So that, I think, is the key area that boards and senior managers need to have made sure that they're in good shape by 31st of March.
Great, thanks, Simon. And obviously you're advising firms on all of these issues. So what sort of challenges have you come across with firms in dealing with this?
There's been a few things actually just that I think firms have had to grapple with. I think perhaps one of the trickiest is where you've got firms that have got an overseas parent. They're the UK regulated entity, but if they're part of a group and they've got an overseas parent, then getting traction from that parent for areas around upgrading and enhancing technology stacks, etc., can be really difficult. And we've seen a number of firms struggling to ensure that its parent fully appreciates the level of regulatory scrutiny that firms and their senior managers are going through to put that in, to get that in place. So I think that's a key one where that overseas element comes to play. I think the other aspect is just the skill sets of individuals who've got this sort of level of responsibility, because it's operational resilience is such a broad area, such a broad role. Finding an individual who's got the appropriate skill sets is nigh on impossible, which is why a lot of the larger firms have actually split the SMF 24 in the UK, effectively the Chief Operations Officer, amongst perhaps 2 or even 3 senior managers. Because if you think about it, if you've got day-to-day operations, a sort of business as usual role, but then you've got the whole area around cyber and tech and IT, which in itself is a significant role that needs to be undertaken, and obviously to some degree having a separate skill set. And then the third thing is just something that impacts where, in fact, we may be seeing some changes to the SMCR, particularly around the certification regime, which is being looked at the moment, and where we think there's going to be a new consultation coming out shortly, where, in fact, the certification regime may be scrapped. Now, for core firms under the SMCR, i.e. the somewhat smaller firms, and admittedly, these new requirements don't formally impact core firms, but there'll be a lot of good practice aspects that will be followed, I'm sure, by these firms. Well, if you're removing individuals who otherwise would be assessed as fit and proper on an annual basis, that's going to put even more pressure and responsibility on those senior managers in those core firms who perhaps before might have delegated to a certified person. So that's the sort of third area of challenge that I think the requirements under operational resilience are going to have an impact for firms come March next year.
That's great. Thanks for that overview, Simon. So, Claire, I guess things go wrong. Stuff happens. Firms do their best, but in these complicated worlds that we live in, things do go horribly wrong, and that's where there's the risk of the regulator stepping in and looking at accountability within firms. Maybe you could talk us through the circumstances where that has happened, and we do have instances of that.
Because I think when the regime first came in, there was a lot of questions around, because the essence of it really is, have you taken reasonable steps? That's at the core of much of what you're supposed to do as the senior manager. And the question was, well, what does that mean? Really, what does that mean? And so there hasn't been an awful lot of enforcement by the regulators around SMCR generally, to be quite honest, but particularly around this issue. But there has been a fine by the PRA against an individual who was Chief Information Officer and SMF 18 as a consequence of something that went wrong on a big IT project. So this individual, Mr. Abaka, he was at TSB and he was responsible. It was actually a split role or split responsibilities, to take Simon's point from earlier. But he had as part of his responsibility complying TSB's compliance with PRA's outsourcing obligations. And he was also responsible for a key outsourcing relationship that the bank had with an entity called Sabadell. And interesting, he had previously been CEO at that entity. So basically, TSB were migrating off an old Lloyds Banking Group platform that they'd been on for many years and onto a platform that was going to be provided by Sabadell. And it's safe to say that the migration didn't go smoothly. And in fact, there was major disruption over a weekend. And basically, although the data were transferred okay, the banking operations over that weekend were severely disrupted. And PRA rules, like FCA rules, require reasonable steps. And the concerns that they raised were mainly around a concern that Mr. Abaka had failed to take reasonable steps to obtain assurances from Sabadell, this third party, relating to their readiness for the migration. And what the PRA found was that the assurances that were given were mainly forward-looking and statements of good intent, rather than actually ones which were in the moment, I suppose, and were testing the situation as it was then. And actually, the assurance letter itself wasn't with the board papers, so there wasn't actually a paper trail in the governance of the migration to show that actually this assurance was something the board had been aware of and had a chance to look at themselves. So the concern from the PRA was that actually this assurance wasn't really stress test, was taken too much at face value, and also that actually the assurances should have been continually tested, and even if they had been of sufficient weight at the right time, that was something that was continually looked at over the migration program. So I think that the lessons to learn from that, and it's not rocket science really, is that there's a strong need for the senior management function holders who are in this situation to really kick the tires. Don't take things at face value, ask the reasonable questions, and be clear in the paper trail as to what you're relying on and why that's reasonable to do so. And I think this final this enforcement notice from the PRA does present, at least I think, some flesh on the bones of what we see in regulatory guidance.
Right. Thanks for that. So I guess, Sophie, that obviously the risk of the regulator stepping in and finding the individual, and that's obviously going to have potential implications for future employment prospects and etc. So it should concentrate minds. How are you finding all this playing out from an employment law perspective, and looking at issues like fitness, propriety issues?
Yeah, so obviously, as Claire says, if somebody is potentially at fault for not having kicked the tires, asked the right questions, reassured themselves that everything is as it should be, that could give rise to a question about competence and capability. And that's one of the three limbs that obviously flows into fitness and propriety. So you get into a question mark then potentially about whether someone remains fit and proper. Would you need to do a triggered in-year assessment? And obviously, if they're not fit and proper, that can have really seriously career-ending sort of impact on an individual. So it's a very serious matter. That sort of due skill, care, and diligence as well could feed into a COCON, a conduct rule breach. So it's really important to be mindful of, are there anything culpability wise that might need addressing internally before you get to the point where you might get an enforcement notice, and if disciplinary action's taken, or in more common parlance, even if disciplinary action in the way that we often think of it as employment law isn't taken, but there's been a remuneration adjustment, that would lead to a notification of a conduct rule breach to the regulator. If that's a senior manager, that's obviously got to be done quickly within 7 days of that finding. And again, that would be something that would be noted on a regulatory reference, and so could impact future employment prospects. So I think, going back to Simon's point, when he said, actually, operational resilience is really wide, and does everybody have the skills to do this? I can see from a senior manager point of view, this will lead to some concerns about, do I have the skills? What is it I have to do? And so the notice that Claire talks about is a helpful roadmap about what are the reasonable steps that should be taken to hopefully protect you if something does go wrong, because things do go wrong from time to time. It's just about making sure you have taken those steps, and then you hopefully don't get into the individual accountability issues.
Right. Thanks, Sophie. Yes, because that's always the concern. So that's very clear outline of the issues, particularly the new requirements coming in shortly in relation to operational risk, and clearly people need to take reasonable steps and probably document those, because the risks of not doing so, there is, as Claire and Sophie have outlined, the risk of conduct rule breach and the notification to the regulator, which itself creates potential concerns then around a risk of being fined or other sanctions being taken against you as an individual by the regulator. But the important thing, I guess, is to ensure that you as an individual take reasonable steps. And if you feel that you're out of your depth, or you feel that you don't have what you need to have to ensure that reasonable steps have been taken, that you can deal with that as quickly as possible to ensure that you as an individual can withstand scrutiny within your own firm or by the regulator in due course. So thank you very much to all three of you for giving those brief outline of the issues that arise in relation to operational resilience, and in the context specifically of the SMCR. So there are plenty of issues that we could pick up, I think, there, and develop into a much longer discussion. But for present purposes, we just want to pick up a few of the highlights. So thank you very much for that. And thank you all for listening today. So for further information on this topic, obviously don't take contact with me or with any of the speakers on today's talk, or your usual Evershed Sutherland contact. So I hope you've enjoyed this brief first episode in the series. And please look out for the next episode, which you can reach in your inbox or social media feed in the near future. Thank you very much.
Thank you for listening to the Evershed Sutherland Legal Insights podcast.